Prince Eichner, and the title of my performance is Justitia Omnibus, Clarence Earl Gideon and the Right to Counsel for the Poor, Changing History from Behind Bars. May I begin? As is straightforward. May I begin? Oh yes, for you mere mortals, that means hear and attend. I am Justitia, goddess of justice. Open your eyes to the reality of equal justice under law. The year, 1963. The place, the state prison in Rayford, Florida. Here is the cell of 51-year-old Clarence Earl Gideon, one very determined individual. Not famous, not an exemplary citizen. He is one mere prisoner trapped at the bottom of the pyramid of power. However, in the United States justice system, it is possible for even an incarcerated criminal to be a catalyst for change, to strike at the heart of injustice, to influence the highest court of the land, and leave his legacy on American legal history. Are you tempted to ignore the plight of this powerless petty criminal? Yes, your prisons are filled with people just like Gideon, men and women disadvantaged by their circumstances, some poor, some illiterate, and a disproportionate number of minorities. Ask yourselves, mortals, why you have so many criminals. Is not your society itself partly responsible for their creation? So many of these inmates, like Gideon himself, were deprived of justice merely because they were poor, unable to hire an attorney, and forced to conduct their own defense in the bewildering circumstances of the criminal trial. Join Clarence Earl Gideon, minimally educated and lacking a lawyer, as he writes his own petition to the United States Supreme Court from behind bars. The Supreme Court of the state of Florida claims that a citizen can get an equal and fair trial without legal counsel, and that the Constitution of the United States does not apply to the state of Florida. But I don't think that's true. It makes no difference how old I am, or what color I am, or what church I belong to, if any. The question is, I did not get a fair trial. The question is very simple. I requested the court for appointment counsel, and the court refused. My biography is no source of pride to me, but being only a human being, I'll try, though I know I can't, justify myself. I was born on August 30th, 1910 in Hannibal, Missouri. I had a miserable childhood, and at the age of 14, I ran away from home. When he came back, my mother had me put in jail. And ever since, I've spent my life just trying to get by somehow or another. I kept doing the same as always, gambling and such, and always ending up in jail on various charges. This time around, I was arrested on June 3rd, 1961, and charged with breaking and entering the Bay Harbor pool room in Panama City, Florida, and stealing some wine, beer, Coca-Cola, and some money. I was convicted of the trial on August 4th, 1961, without having a lawyer. And on August 27th, 1961, they sentenced me to 5 years in the Florida State Prison. I should have been given an attorney. I petitioned before the Supreme Court for a writ of habeas corpus to be released, because I believed my trial was unconstitutional. But they denied my petition, and my only hope now is that the U.S. Supreme Court will grant a writ of certiorari and be willing to hear my case. More than 5,000 inmates here in Florida jails alone had trials without lawyers. And what happens to my case affects them too. I'll tell you, I have no illusions about law, the courts, or the people who are involved in them. But I do believe that each era finds some improvement in law, and each year brings something new for the benefit of mankind. Maybe this will be one of those small steps forward. Gideon felt strongly that without an attorney to plead his case, the balance of justice was tipped decisively against him. And it was. I think that's the right one. Troubling the affairs of man, how you mortals struggle to balance justice. The Magna Carta, in the year 1215, which planted the seeds of the U.S. Constitution, created in 1788, Supreme Court cases dealing with counsel for the poor, such as Powell versus Alabama in 1932, and Johnson versus Earth in 1938. The 14th Amendment, nor shall any state deprive any person of life, liberty, or property without due process of law. The balance of justice for the poor was improving until 1942, when the Supreme Court decided the case Best versus Rainey, ruling that due process required that states provide counsel only in cases involving special circumstances, such as youth, illiteracy, or complex charges. Prisoners who had been denied habeas corpus by the state courts were flooding the federal courts with petitions insisting that their special circumstances had been denied, but they should have had an attorney. The the Supreme Court was constantly overturning the decisions of the state courts. Uncomfortable with this high level of intervention, which they believed was invasive to the balance of federalism and corrosive to states' rights, the Supreme Court was poised to overturn Betts versus Brady. But they needed a petition just like Gideon, one that did not allege special circumstances, giving them the opportunity to restate counsel for the poor as a constitutional right under the 14th Amendment. And so, the Supreme Court did grant certiorari to Gideon's case, setting the oral argument of Gideon versus Wainwright for January 15, 1963. Understanding its enormous legal significance, they appointed a prominent D.C. attorney named Abe Fortas to represent Gideon's cause. I listened intensely while Mr. Fortas made his argument. Chief Justice, please the court. The question this court is asked me to argue in Mr. Gideon's case is whether or not Betts versus Brady should be overturned. I do believe that in some of this court's decisions there has been a tendency from time to time, because of the pull of federalism, because of the understandable need to accommodate the state's rights, to forget the realities of what happens downstairs. Of all the rights the accused person has, the right to be represented by counsel is by far the most pervasive, for it affects his ability to assert any other rights he may have. If our vaunted claim of equal justice under law is to be more than an idle pretense, the right to have counsel must be extended in practice to all persons accused of crime. Currently, 5 states, including Florida, make no provision for providing counsel to indigent defendants. Betts versus Brady dangerously tilts the scales against the safeguarding of one of the most precious rights of man. For in this world, no man should be condemned to penal servitude without having the right to counsel to defend him. The right of counsel for the poor as well as the rich is an indispensable safeguard of freedom and justice under law. All I wanted was to get out of prison. Now I realize that this case is important to a lot of people in here. We've been waiting a long time for the Supreme Court to deliver its opinion on my case. I said right from the beginning that the Constitution entitles me to a lawyer, and it looks like the Supreme Court thought so too. Here's what Justice Black wrote in the majority opinion. March 18, 1963. Reason and justice require us to recognize that in our adversary system of criminal justice, any person haled into court who is too poor to hire a lawyer cannot be assured a fair trial unless counsel is provided for him. Lawyers in criminal courts are necessity, not luxury. I believe this actually will be a new benefit to mankind. And so it was. The Supreme Court's decision in Gideon versus Wainwright mandated that all states must provide counsel for indigent defendants in all felony cases. This mandate led to the creation and expansion of public defender systems throughout the state. Clarence Earl Gideon was retried with the benefit of a lawyer and found innocent. Have the ideals of fairness and equality promised by the Gideon decision been fulfilled? Today, America's public defender system handles over 4 million cases each year, and yet it languishes with inadequate funding, insufficient resources, incompetent counsel, and unmanageable caseloads. And so my scales remain unbalanced. Nevertheless, as one of your famous mortals, Robert F. Kennedy, said, if an obscure Florida convict named Clarence Earl Gideon had not sat down in his prison cell to write a letter to the Supreme Court, the vast machinery of American law would have gone on functioning undisturbed. But Gideon did write that letter, the Supreme Court did look into his case, and the whole course of American legal history has been changed.